Here is a question the Supreme Court could answer today. If you want to seek asylum in the United States legally at an official border crossing, exactly the way the law says you're supposed to, does the law protect you? According to the Trump administration, argued before the Supreme Court this morning, no, it doesn't. If you cross the border illegally between ports of entry without authorization and then ask for asylum, yes, the law protects you. Do everything right, no protection. Break the law to get here, full protection. That's not my framing. That's what Justice Ketanji Brown Jackson put directly to the government's lawyer this morning. And the lawyer didn't have a clean answer. I'm Mucho Balinda. This is the third voice. And today we're going inside Noem versus Otro Lado, a case argued today that could redraw the constitutional right to seek refuge in America. Let's establish the policy at the center of this case. It's called metering. Metering is not a wall. It's not a ban. It's a line management system, and that framing is doing a lot of work. Here's how it worked. When migrants arrived at an official U.S. port of entry and asked to apply for asylum, border agents would turn them away, not process them, not interview them, turn them away, and tell them to come back later, or put their name on a list with no guarantee of when they would be seen. The official justification, capacity. The ports were overwhelmed, was triage. The result? Tens of thousands of people, many fleeing incredible violence, were left waiting in Mexican border cities, living in makeshift camps in some of the most dangerous areas in the Western Hemisphere. The policy started under the Obama administration. It was formalized and expanded under Trump's first term in 2018. Biden rescinded it in 2021. And now, in 2026, the Trump administration is back before the Supreme Court, asking the justices to declare it was legal all along. Why does a rescinded policy matter? Because the administration wants it back, not as the law of the land right now, but as a tool in reserve, a constitutional permission slip. Here is where we get into the constitutional mechanics. And I want to be precise, because this case turns on 5 words. Federal law says that if a non-citizen who, quote, arrives in the United States, close quote, expresses fear of persecution, the government must refer them for a credible fear interview. That's the mandatory duty. That's the trigger. The entire case hinges on what arrives in the United States means. The government's position is simple. You haven't arrived in the United States until you are physically inside its borders. Someone standing in Mexico at a port of entry has not arrived. They're in Mexico. End of analysis. The government lawyer put it bluntly this morning. You can't arrive in the United States while you're still standing in Mexico. The challengers, an immigrant right group called Otro Lado, and the class of asylum seekers, think that's too narrow. When you present yourself to a U.S. official at a port of entry, you have functionally arrived. You're at the threshold. The process has begun. The law was designed to cover exactly that moment. And here is where Justice Jackson's question becomes devastating. She described a polite asylum seeker, someone who wants to do everything right. They approach the border. They don't cross illegally because the law says you're not supposed to enter without authorization. They present themselves at the port of entry. They follow the rules. Under the government's reading, that person gets nothing. their request is not entertained. The law doesn't protect them. But someone who crosses the Rio Grande illegally, walks onto U.S. soil, and then says, "I fear persecution," they get a credible fear interview. The law protects them. Justice Jackson's words, "Why on earth would Congress have intended that?" Question. And it is one the government struggled to answer cleanly. Now, and this is important for anyone watching this channel, the conservative justices were not a monolithic wall. Some were clearly receptive to the government. Justice Alito offered an analogy that someone who walks up to the front door of a house and knocks, have they arrived in the house? Implication? No. They're at the door, not inside. Justice Gorsuch went further, probing the absurdity of the challenger's position. If the border runs through the middle of the Rio Grande, does someone arriving at the waters on the Mexican side get asylum protection? What about one step into the water? 2 steps? At one point, and I want you to hear this, he asked about migrants scaling a section of border wall that sits right at the boundary line. So at the top of the wall, they're in, but at the bottom of the wall, they're out. The courtroom actually laughed. But here's what the conservative justices' question also revealed. Even they found the line drawing uncomfortable. Justice Barrett asked, "How close do you have to be to the border?" If the court rules for the asylum seekers, where exactly does coverage begin? That's the line she could find in the statute. And she was skeptical both sides had a clean answer. Justice Kavanaugh raised the same paradox Justice Jackson did, from a different angle. He pointed out that the government's reading privileges illegal border crossers over those who do it the right way. He asked, why would Congress privilege someone who illegally entered the United States? That's not a liberal question. That's a textualist question. And he has no good answer under the government's theory. I want to step back from the legal mechanics for a moment, because this case doesn't exist in a vacuum. In court papers filed in this case, HIAS, formerly the Hebrew Immigrant Aid Society, invoked the MS St. Louis. That's the ship carrying over 900 Jewish refugees that was turned away from Cuba, turned away from the United States, and turned away from Canada in 1939. Most of those passengers were eventually murdered in the Holocaust. HIAS argued that Congress passed the modern asylum statutes to prevent that from happening again, to ensure that people fleeing persecution could not simply be turned away at the door. That safety, visible but unreachable, would not be the answer America gave. Justice Sotomayor made this argument from the bench in the starkest terms. She told the government lawyer, "What you're describing is the equivalent of the MS St. Louis, turning people back to be killed wherever they end up. And the statute," she said, "does not permit that." The government's response, U.S. law doesn't obligate us to process claims from people who are not physically on U.S. soil. The international principle of non-refoulement, the obligation not to return refugees to places where they faced persecution, isn't enforceable as domestic U.S. law. One asylum seeker whose story was part of this record described presenting himself at the port of entry after experiencing serious violence. He told the U.S. agent he feared for his life and needed to apply for asylum. He says he did everything correctly. Under the policy being defended before the Supreme Court today, his application would not have been entertained. Before we get to what this means for you, I need to flag something that constitutional law professor Steve Vladek called weird. And he's right. The metering policy isn't in effect. The Trump administration currently uses other authorities to block asylum seekers, not metering. So why is the Supreme Court deciding this? Justice Jackson pressed this point hard. Under Article 3 of the Constitution, federal courts can only decide actual live cases and controversies. If the policy is gone, is there still a case? She argued the court should dismiss this as moot and stay out entirely. The government's answer: we want the option to bring it back. We're asking for a ruling so we have legal clarity if we do. That's an unusual posture. The Supreme Court deciding whether a tool the executive branch might want someday is constitutional. But the court took the case, and today, a majority appears ready to rule. Here's the pattern I want you to see. Congress passed the asylum statutes after the Holocaust, after the MS St. Louis, after America watched what happened when desperate people are turned away at the door and called it a border management decision. Congress wrote a law that said, when someone arrives and expresses fear, the government must act. Must, not may. Must. What's being argued before the Supreme Court today is whether the executive branch can redefine the word arrives to mean that someone who's standing at the door hasn't arrived yet. And therefore, the mandatory duty never triggers. And therefore, the law Congress passed in memory of those who died can be bypassed with a policy memo. That's not a border security question. That's a separation of powers question. Who gets to define what a statute means? Congress, which wrote it, or the executive, which wants to narrow it? A decision is expected before the end of June. I'll be here when it drops. If this analysis gives you something most commentators want, share it, subscribe, and I'll see you in the next one.